And as you're signing that, Your Honor, I have conformed copies. I'll take care of that after the hearing's over, get that to the state and to the appropriate entities.
The only thing I did in the first order, I had put after granted production has occurred.
Thank you, Your Honor.
Okay, and which one of the three motions that you have scheduled for today would you like to hear first?
Probably the motion for an order granting an issuance of subpoena ducis tecum as to 7-Eleven Corporation, Your Honor.
Okay, I have read your motion.
Thank you. We have noticed 7-Eleven. I'll tell you that their response was somewhat informal. They didn't seem to have much of a concern about it. So I am going to ask that the order be entered. The state did raise a concern, though, that I think should be in the order. The information that we're requesting is going to include information to, obviously, non-parties of the matter, people in the public who had no intent nor desire to be involved in this case. So I think that the order should read, as the orders concerning school records and medical records, that they ought to be held confidential. So this order doesn't say that. I'd rather draft one that does say it properly and then present that to you, or you to grant the motion.
Okay, with that caveat, is there any objection from the state?
With that caveat, I have no objection, Your Honor.
Okay, thank you. The motion will be granted with the caveat of confidentiality. If you'll please get an order to Mr. De La Ronda, and if there's no objection to the form of the order, so state in your cover letter. Next, you had your motion for specific discovery.
Yes, Your Honor. It may be better to just attend to the motion to continue first, only because I think that's going to dovetail into the specific discovery.
Okay, I have read your motion and the response from the state.
The only additional argument is I need more time.
Okay.
We've been working really hard on it, but we need more time.
State, any additional argument?
Very briefly, Your Honor, and I know that at the prior hearing, the sides, defense and state informally, I guess, had a gentleman's agreement that the documents or the motions would be filed with enough time to allow the state to respond. And there was some disagreement. I'm not implying that anything was sinister on the part of defense in terms of whether it was 48 hours or 24 hours before the 48-hour deadline that the court imposed when motions to be filed. So I did do a very brief response, but I just wanted to highlight certain things regarding their motion. So if the court will give me the opportunity to just briefly highlight certain things that are stated in their motion that I did not specifically respond to in my motion. My response was just a very generic response saying that the defense, I feel, has enough time to accomplish it. You know, we're early. It's February, and the trial is set for June, so we've still got technically 4 months to go before the trial. And so I think they have enough time to accomplish what they did. But I just wanted to, I guess, highlight certain things regarding his motion, which I think, without clarifying, a person reading it would go, wow, is that accurate? And so I wanted to clarify a good thing. So if the court has that motion before it, the defense motion, I wanted to respond to a few things. On page number 2, and I guess page number 2B deals with the specific discovery, so I'll respond to that at that appropriate time. But on page 3, under subparagraph C, there is mentioned that there was a meeting at FDLE on January 9th. And I think that's significant because the court throughout a lot of these discovery issues has alerted or suggested to the defense that they have an opportunity to go to that agency and get the actual documents. And that actually was accomplished. Now, for some reason, in their motion, they make a big point about Mr. Lee, Special Agent Lee, was present and he was not allowed to be questioned. Well, Mr. Lee was deposed, I think, a week or two after that. And, in fact, the FDLE agent said, listen, this is for you to look at the evidence. This isn't like an inquisition where you get to ask some questions. He's going to be available for deposition, and he was. So my point is there is a process that, quite frankly, the Supreme Court has approved of, and that's called discovery. Florida is unique in, I think, only 4 or 5 states in the nation that has a full discovery, full deposition process. And I just guess I would urge the defense to avail themselves of that opportunity. They have. Quite frankly, both sides working together, as the defense pointed out, have accomplished a lot in terms of depositions taken. We've taken the burden, which we wouldn't have to, but I want this case tried in a timely fashion, to have our investigators who are coming from Jacksonville every time and ensuring that witnesses show up, either physically going and pick them up. That's a lot of time from our standpoint. So we are, as the defense acknowledged, cooperating and trying to do everything we can to facilitate these witnesses from showing up. Quite frankly, there have been a few witnesses that the defense has talked to previously through the depositions now. They have every right under the law to do that. And they've spoken to, they spent an hour or two talking to them, and then we go and depose them, and then they rehash the same thing. I am not complaining about that. The defense has an opportunity. But my point is, the state can't control the methodology that they use or how fast or how slow they work. I can only respond to what's asked of the state and try to do it as quickly as I can. On page 4, there's mention of the injuries to Mr. Zimmerman's face. I don't know why we're having to rehash that in the motion to continue since that was already provided. The defense just made a big deal that they didn't get a color digital. I just ironically note that in the motion that I got, this is a black and white photograph, by the way. So they make a big deal about this color. So what was so urgent that they needed to have that color digital photograph that placed the burden on them when they couldn't do their job?
In the court file, the one to the court, there's a color one too.
Okay, well, my copy's only in black and white, just as like I tendered originally to the defense, a black and white. But my point is, that did not delay the proceedings at all. And by implication, in some way, they say that took a lot of time and that in some way delayed their progress in the case. How did that delay it? Other than flashing it in front of the media so that it would be a highlight thing for potential jurors to see, that he had some blood on his face. Witnesses, I apologize, on page number 5, witness number 8, recorded interview with Mr. Crump. That's been provided. We've actually not just given them the recording originally that we got from Mr. Crump through FDLE, through the FBI. We actually went one step further. We actually got the actual recording device itself and made another copy of that. I don't know that that's delayed this case, but that was provided. Mr. Martin's cell phone. I will admit that the process in getting that evidence was time-consuming. Quite frankly, I worked with the defense in accomplishing that because, as noted in their motion, originally nobody could break into Mr. Martin's cell phone. And when I say break in terms of getting the password to actually go in, and when we looked at the phone at FDLE, when the state, with the cooperation of FDLE, provided all evidence to the defense that they could just take their time in looking at it. In fact, they went to the trouble of taking color photographs. I'm assuming they photographed it. I don't know if it was colored. And they looked at the phone. We figured out that the phone was nobody could get into it. We actually had the agent that was involved in that come into the meeting, even though he wasn't being deposed, and he explained extensively that. Well, as a result of that, and I guess I'll get into it into specific discovery, that phone was sent to California because there was a sheriff's office there that could actually crack into the phone, and he did. And then it was sent back, and then it was sent recently to Celebrite up in New Jersey. Now, at that point, regarding Celebrite, the defense was given an opportunity to go up there with them, and at one point they made arrangements to go, and they decided not to, which is fine. But I guess we're being blamed because of all that process, how long it took. This is a new area that we're trying to deal with, and quite frankly, I think it's been very thorough in terms of the opportunity for the evidence to be made available to the defense and for the defense to depose the witnesses. FDLE file information, Your Honor, after every hearing, if there is something that I think is missing or something, I go back and I check with the agencies again. As a result, I supplement discovery, in fact, I did this morning. Regarding depositions, I guess the defense is saying they're not prepared for the following reasons. They want to take a deposition. There's some that are still outstanding. I know the court has had an opportunity to read my response, and I know the defense has been working hard to try to move this case. My frustration with the defense is that sometimes we set aside days of depositions, and then they're canceled. Now, for whatever reason, they're canceled. So it's frustrating from the state standpoint. We don't live here. We're not complaining. We come from Jacksonville every time, but it takes time from our schedules to come and schedule a whole day. I've got to tell judges in Duval County that I can't have a hearing that day, or my case can't be set for trial, or Mr. Guy's case can't be set for trial because we've got to come for a deposition. And then all of a sudden, depositions are canceled. And so that's frustrating. I realize the defense has other stuff going on besides this case. And I realize sometimes it's out of their control in the sense of an attorney representing the witness, such as like the police department. One of the attorneys representing the Sanford Police Department was not available on certain days. But I guess I would, and defense has complied to this at some point in terms of my request, want to have as much advance notice as I can to allow those witnesses an opportunity to come in so that there's no issue about there being any delays in this case. Despite sometimes the day before or 2 days before, our investigators have come down here, have located the witnesses, and have brought them into the deposition. So we deal specifically with Mr. Crump. And I know that something has been filed today. I believe both sides have been given an opportunity. My recollection of the deposition of Mr. Crump was regarding specifically, the only issue was the recording of witness number 8. And I know Mr. Crump is here in the courtroom, as is at least one of his attorneys, and I guess we'll deal that at some point. Regarding witness number 8, the deposition of witness number 8, I urge them to take that deposition. I mean, I realize she lives in Miami, and I know it's going to be an ordeal for the defense to go down there. We're going to have to go down there, too. It's going to be even a longer trip for the state, but we're willing to do that. I mean, we need to go ahead and move on and get this thing done. Regarding the victim's family, they're available. They just want due notice, and they're going to make themselves available for deposition. So, depositions are taken all the time, and they're willing to be deposed. Regarding Investigator Irvin, the court's already ruled on that, and I've already argued regarding what happened there. And then regarding Detective or Investigator Sereno, I've spoken to his attorney. He's available for deposition too, so we just need to set them. Now, regarding the expert assistance, I really can't respond to that other than, the defense is saying they need to hire some experts. I don't know what for, but they can address that. And finally, Your Honor, regarding the influence of the ability of the defense to prepare, as I noted in my motion, I guess they say, well, we had a problem because we had to spend time addressing a writ prohibition to basically remove the prior judge. The 5th DCA has already ruled on that. But the issue came up, quite frankly, because of the defendant and his wife, what occurred in the courtroom. It wasn't like the judge on his own said something or ruled a certain way. That was brought about by the defendant and his wife lying to the court. And so then when the defense goes, oh, that delayed our preparation. Well, who created it? The defendant did. And then they talk about also that's all this various social media, blogs, media outlets, that's delaying the case because they're having to spend more time. I will concede, I've been doing this, in April will be 30 years, that this case has gotten an enormous amount of publicity, probably more than I've ever, in cases I've handled. But I've never had a case, maybe here in Central Florida it's a normal thing, where the defense creates their own website, creates their own Facebook, creates their own Twitter, and just publishes stuff out there, encourages discussion among various groups. At some point they realize that Facebook apparently isn't working, or there's some problems with it, or there's some doxing, I believe is the word that is described as occurs, and I'll relate to that in terms of their motion for specific discovery. But I guess I find it ironic that the defense complains that they're now having to address all these issues that, with all due respect to the defense, they helped create. I mean, I have filed on behalf of the state of Florida, I believe, 2 motions for gag orders. And respectfully, Judge Lester, and now Your Honor, has denied those motions. And I'm not here to argue those again, but my point is the state has been trying to try this case in the courtroom. I don't know that's true of the defense, but I'm not here to...
We'll get back On track
I
with the motion
apologize.
to
My
continue.
point is that they argue in part of this motion that they're now having to spend a lot of time addressing all these issues. And these are the issues that they created or helped to create or encourage people to respond to. And I think it's odd that they make their argument in such a way. So I guess my point is we object to a continuance. When they told me November, I said, okay, that's like a ways off. If the court were to continue it for a month or two, but this is ridiculous. It's going to be harder in November, December, when jurors have potential conflicts with the holidays to pick a jury then. And so I would just urge the court to deny their motion because I think they have enough time between now and then to try the case. And I know part of their argument is that they need this Twitter stuff, and I guess we'll deal with that in their next motion. Thank you very much.
Brief response,
Briefly.
Yeah, just a graphic representation of the frustrations I outlined in my motion, if I might. What it really is just taking what we've asked for example, the addresses of the witnesses, Mr. Martin's cell phone, FDLE file. The green is when we asked for it. The blue is when we got it. So when you see those 6 and 8 and 10 months delays, we can talk back and forth about setting up depositions, and we can talk back and forth about 11, 12, maybe today, when there's a hearing to compel what he hasn't given us before we get it the morning of the hearing. We can look at that and say, okay, he's now complied. But the reality is the blue is our waiting period on each and every event. And this is only the top 6 or 7. We have another dozen, but I don't think we need to go over the court with them. My frustration is that I want to get this case done. You're probably aware of the case that just started trial today. Peanut Baker is being charged with shooting a cop, shot him just above the breastplate. He survived. It's an attempted murder charge. And he's going to trial. His trial started today. And he shot him 3 years ago. So we are, in fact, a month shy, several days shy of the anniversary of the shooting in this case. We are working hard. We are running into an enormous amount of resistance, that which I am showing you. And because this case is such high profile, I will be very clear with the stating with the court. I spend virtually no time on the Twitter and the website that I have because it doesn't matter that much. But we will not and cannot ignore the avalanche of information that's flowing through the blogosphere about this case, because I think, and I mentioned this to you before, I think if it's not malpractice in 2013, it's about to be. That's just ignoring information that's out there that we have to disclose. I don't want to. I will call my wife as an expert witness that I want this case tried in June. There is no benefit to the defense team. There is certainly no benefit to Mr. Zimmerman, and there's no benefit to the Martin family to keep this case going, and I'm very sensitive to that. But the reality is we have to try it once, and we have to try it keeping in mind the Sixth Amendment that says he has a right to a fair trial and a vigorous defense. And we are being vigorous. But as we're about to morph into with the motion for specific discovery, if we have to wait, if Mr. De La Rianda is going to say to you, to me, I am not going to tell you the name of the California law enforcement agency that we just decided we're going to take the phone out of FDLE, if that's what we're going to have, then I'm going to need even more than November. But for right now, I think November is a good trial date. I do think that what we really should do is set a status date in a few months, maybe July or August, so that we can tell you where we are, but that we also should keep these monthly hearings before the court, because I hope that you're getting the flavor of at least my side of the frustrations that we're having with discovery and the fact that we're really trying to get this case done. So that's my sort of response. We want to move it forward, but we are running into some resistance.
Thank you very much. On October 26th, this court, when we were in session, asked the parties when they would be ready for trial, and the response was June 2013. Based upon that, I issued my scheduling order on October 29th, 2012, setting the trial to begin on June 10th, 2013. In an effort to assist counsel with discovery issues and matters in this case that needed to be heard, I had set aside full days for hearing. December 11th, 2012, only partial day was used. I said hearing set aside for a full day on January 8th, 2013. I got a phone call that time was not needed. And then I set this hearing for today, February 5th, 2013, and I got a phone call that maybe we would need 2.5 hours. I've also set aside March 5th all day, and if needed, I have April 2nd, April 30th, and May 8th all day. It is now council entered appearance to represent Mr. Zimmerman on April 12th, 2012. That's almost a year. We're 4 months away from a trial date. I don't see any of your issues to be insurmountable. The court has no reason to continue the case, therefore the motion to continue is denied.
I appreciate that. Just one clarification, Your Honor. When you asked me in October when the case, I thought it would be ready, I told you I could not tell you that I would not have that information available to me until we were into discovery. So I just want to make sure the record's clear that I did not say that this case would be ready in June. I specifically told you it was well too early for a case of this magnitude for me to give you that information.
Okay, thank you very much. And then your next motion is the motion for specific discovery. I have read your motion and your memo from October. You had put in a cover letter that you were relying on the motion, the memorandum of law that you filed on October, I think it was 25th, 2012. I have reread that. You may proceed.
Very simply, Your Honor, I could easily just bullet point the memo of law, but I think that we do have a dichotomy in how we're viewing discovery in this matter. If, in fact, you take the state's restrictive view of discovery, then we'll just keep trudging along at this pace, and we'll deal with it. If, on the other hand, you review the memorandum of law and suggest within it that some of the cases that reference it, such as the Martinez case referenced on page 5, the Giglio case, which actually expanded Brady significantly, saying, in effect, that the state has the responsibility not only for what they are aware of or have already put into their file, but I think Giglio, Martinez, Kiles versus Whitley all stand for the presumption, for the rule of law, that the state must gather that which is in other state agencies' hands. The frustration and the specifics that we reference in this motion talk about FDLE. We have now been, you've seen in the motion the progression of the FDLE occurrences. It wasn't until we set up, although Mr. Delarianda actually told them to be there, but we were the ones who requested that we go look at the evidence. It was only at that point that we found the phone, and coincidentally asked for it to be turned on, found out very coincidentally that a report was done. Sent him for a deposition, found out at that point that he had more information than was disclosed. And we, I'm not going to belabor what's you've already read in the motion, but the reality is, if in fact that is the style of discovery that this court is going to adopt, then unfortunately we will not be ready, be it June with the motion to continue denied or November. And the frustration is that these are specific discovery violations. Now, granted, most of this case law is only when they're caught afterwards, only when we try a case, and then we find out about missed Brady material. I mean, all of the case law is because, quite honestly, normally you don't run into these problems pre-trial because you have a conversation and it gets resolved or the court involves itself.
I've read everything. I just want to know specifically what it is that you're saying that you do not have and that you're entitled to have. I know you would put forth in your motion. Let's start as regarding the Twitter and Facebook information regarding Trayvon Martin and witnesses.
This court, and we argued that, that there is no basis in the case file, there is no previous order, but this court adopted what it perceived to be an order from a previous court saying we don't get the demographic information on redacted or protected witnesses. We contest that as an improper order, but we are now bound by it. I would ask that you may want to consider reviewing that, but in any case, so we don't even have demographic information. I think what you said was just go take her deposition. And we can, except, of course, the state resists every time we try and take her. The one time so far, we've tried to take a second deposition. So I am now at the point where... Tell me, to be specific, of who? I want Mr. Delarianda to call...
the deposition of who?
Of witness 8.
Okay.
I want witness 8 and also the Martin family. Because as to the Martin family and Witness 8, they have the information that we need to move forward with the Twitter and
Understand that.
Facebook.
Have you sent out subpoenas? I understand Witness 8, you may not have the address, but did you send a subpoena to the state and require them to produce her on a certain date?
We produced what?
Witness 8.
No, because I don't want to take a deposition until I'm prepared.
Well, you just told me that you're not able to get these depositions taken. I'm trying to understand
sorry.
what your specific issue is so I could try to address it.
I may not have been clear. In order to move forward with other avenues of discovery, such as getting the Twitter information what this court allowed me to get, in order to do that, I need a piece of information. I need her what's called a Twitter handle. Without that, the subpoena is worthless. It's like asking for a bank account without knowing the
I
bank.
understand all that. I want to try to get that resolved. Is there any, I know in other cases you make a phone call to a witness before you take their deposition.
I would love to do that.
Okay.
Maybe I can just get a phone number and I could do it myself. The
Or
problem
maybe
with
you
it-
could call the state and they can have her on a conference call and you can ask that question.
I've asked for weeks. I actually asked.
Stop. Mr. De La Ronda, is that something that we can accomplish so they could get that account name?
Yeah, may I just respond to that very briefly?
Anything long, I just want to know the answer to my question, please.
This witness has not been given notice, and there's been a hacking or a doxing of what was perceived to be this witness, that in fact the defense responded to in their own website. That is, an innocent woman, a girl who was not involved in this case at all, was targeted and was, oh, we've got her, this is the person, and it turned out not to be the person. So the defense has requested me to find out if witness number 8, and I appreciate the fact that we're all agreeing to call her by witness number 8 as opposed to her name. What is her Facebook or Twitter? And then they also want, then they said, okay, but no, you can't do that. You just got to get an affidavit too. My suggestion is she be deposed. They asked her under oath, so there's no dispute about what she said or didn't say. And then if they need to follow up on that specific issue, I would not object to them redeposing on that specific issue only in terms of whether she said something or didn't.
Okay. Well, the argument from the defense, and correct me if I'm wrong, is they need to see what is on those accounts before they even know what they want to inquire of her as to a deposition. So we have to take it one step at a time. Is there any objection to getting a conference call, having a court reporter or somebody available to take her oath on the other end, just for the purpose of asking what are your account names or numbers so they can access the account?
If it's done that in that manner in terms of, so there's a proceeding, so there's some kind of documentation, then I would have no objection to that.
Nobody has to drive to Miami. You could have her at a court reporter's place of business. She can show her identification. She could be sworn in. Both of you could be on a conference call and can ask her those questions, and then you can move forward with her depo.
I have no objection to that proceeding. With this caveat is the only thing I would request, and I don't know that the defense will have an objection to that information not be revealed, that is publicly, because...
I could keep it as confidential until a later time that the court orders it's not.
As we can. Unfortunately, and I'm trying to work with Twitter and Facebook in this regard, they have to respond to a specific subpoena. I'm going to ask for confidentiality, and I think that they will afford it, but they need to know who it is.
Well, but I think that the process that I just set forth should suffice for that purpose.
And that's also as to the Martin family, I presume.
That would be the same.
Yes, Your Honor.
You'll designate who the person that can give those IDs, and we could do the same procedure.
Yes, and quite frankly, I think they actually have some information regarding both of those individuals, because the telephone records, not just recently, at the beginning in terms of when they've gotten, have a lot of that information in there. And also, Mr. O'Mara, from the very beginning in this case, told me that he had gathered that information even before there was a request for it. But I believe they have some of that information already. Now, whether it's accurate or not, and that's the problem we have with Facebook and all that, is it accurate? When was it posted? Who posted it? And so,
We'd much rather get accurate information. I appreciate the order in that regard.
Okay, and then...
Second one?
The second one is the disclosure of the existence of witness 8's identity to the state, wanting to know when the state found out who witness 8 was.
And
Is that
perhaps
correct?
we can expand witness 8's mini deposition to include just those few questions. There is a black hole wrapped around witness 8, and we know when she shows up in Mr. Crump's informal interview of her, we don't know where before that. So all I'm asking, and I'll take her deposition to those questions as well if you allow it, is where was she, who was she talking to, and that information. Because the state, when we asked a dozen times, simply will not tell us how they first found out, and I guess we'll just ask her. So I would ask that we expand that deposition just to include that issue as well.
That's why I suggested we just take her deposition. I mean, it's easier for all of us to go down to
If you're going to keep expanding the purpose of getting more information from Twitter, then you're going to be taking 2 depositions, and I'm not going to allow that.
Okay, then let's do this. I really want to know, I have a right to know when a witness came into the view of the state.
And you have
so
the right
let's
to
ask Mr. Delarianda when he first found out about this witness.
But the rules of procedure do not require them to tell you when you can get it from another source. You just have to take witness 8's deposition and ask witness number 8.
And, well, to the extent that we hope she knows, but how would she know when the state first became aware of the information? Because that's what's relevant for my purposes.
Take her deposition and ask her.
As to those 2 issues?
No. After the first telephone deposition is just for Facebook, Twitter, ID account numbers. Then you can take her deposition and you can ask away. Okay, and then the next one is the particulars regarding the cell phone analysis done in California.
Yes, Your Honor.
That Mr. Dellaranda had already touched on, so let me hear.
Well, I don't know, because today, after having done everything that we've done, we get what seems to be a 12th supplemental that says, I don't know what it says, SBCS California, chain of custody. I don't know if it's a report. I don't know what it is.
Okay, Mr. Dellaranda, without going into a big history of what things have happened or not happened in this case, can you just focus for us on the cell phone and the analysis? Where it's been and what is the meaning of the new supplemental
I'm glad to, Your Honor.
discovery?
As Mr. O'Mara and Mr. West know, because he briefly touched upon the fact that when we were at FDLE, the phone couldn't be accessed. That phone was taken, and as noted in discovery, to the Santa Barbara County Sheriff's Office, to a Perry, and the last name is Kuhl, who actually opened up the phone. He found the code to open up the phone. He didn't do any more analysis or retrieving of information. He then sent it back over here. It's sat at FDLE. My investigators were involved in handling it from a chain of custody, and they're aware of that. And then it sat at FDLE, and then FDLE, Steve Breton took it physically himself to Cellbrite. And Mr. O'Mara and Mr. West have both been aware of that. In fact, they were given the opportunity. At one point, they requested to go, and I said, that's fine, but this isn't going to be a deposition. You can be present, you can watch while everything is done, and they determined that they did not want to go. And so they were given the opportunity. That information has been brought back. The CD has been provided to the defense.
Is the phone back here?
Oh, yes, yeah, and the information retrieved from that phone is also, using an extraction process, was actually given to the defense, I believe, maybe 2 or 3 weeks ago, but I may be wrong about the date. And Mr. O'Mara has reviewed it from what he told me, but he requested further time to do it before Mr. Breton is deposed. So that information, now, the gap that they were talking about was the information about where in California, and I provided that name. That's just a chain of custody, but I will make that witness available if he wants to be deposed by phone, or we can fly to California if they need to depose him.
Does that help clarify what you were seeking in your motion for specific discovery?
To be honest, I think it's a start, but I have no idea what Perry Kuhl did to the phone and how long he had it. This doesn't tell me that. What this tells me, if we're going to get into the specifics, is that on November 8th, 2012, David Lee got the phone from the 5th District, from the State Attorney's Office. Quite honestly, I don't know how they got it, because I thought it was always in FDLE. But then, in November 9th, They gave it to Brenton for the content. So if that's the initial one, so be it. Then we have...
Can I ask, is there any way that you could just give defense counsel a chain of custody for the cell phone?
They had two papers.
A log?
Yes, Your Honor. That's already been provided, and I will be glad to connect the dots, Mr. O'Mara and Mr. West, because the prior two documents that were referenced in his report and his motion, they got when they got all the FDLE documents, the stuff in terms of it coming back. I attached the next two, the next two chain of custodies. These were previously.
Okay, this has nothing to do with California. This, I presume, has something to do with California. I would like to know what. This doesn't tell me when it went out there and what evaluation was done to it.
I want the state prior to, can you get it done by Friday at 5 o'clock and fax it to counsel? A log for chain of custody.
Yes.
And then if you have some issue regarding that and you need time before our next hearing time, you could call my JA and I will make time for this issue.
And they will also tell us what tests were done and what reports were generated? I presume a report was generated. I have to believe that law enforcement generated a report.
Sometimes instead of just different supplemental discoveries, if you put it in one report, it may be easier to follow. So if the state would do that, put the chain of custody, the dates, and what work was performed at each place.
Yes, sir.
Okay. And do you think you can get that done by Friday, the
Yes,
8th?
Yes.
We have a next hearing date scheduled for March 5th, 2013 at 9 a.m. You can have all day in this courtroom, courtroom D. Then I have, following that, April 2nd or April 30th, or both. So do you want me to set aside those 2 days?
Pursuant to your now denial of the motion to continue and the timeline set out in your order, we would have to have our expert witnesses to the state in about 25 or 30 days. I would tell you that's not going to happen. I don't know how else to say it. That will not happen. So we will now be precluded from presenting expert testimony. But regardless,
I can tell you this, both sides, that you have known since October that the trial date was going to be on June 10th. You now know that the court is denying your motion to continue. The court expects counsel to abide by the court's orders.
and we will. I'm just acknowledging that we are not going to be able to have expert witnesses available as your schedule requires because we don't have them. So
I will keep March 5th open all day. I will keep April 2nd and April 30th. If there is an issue that comes up prior to those dates that needs my immediate attention, if you'll call my judicial assistant, she will make sure that I make time, and I will come over here and we'll hear whatever it is that either side deems to be an emergency. Okay? Is there anything else that we need to take up in this case before we recess? Mr. Blackwell. Good morning.
Good morning. Have I ever appeared before you, Your Honor? Probably, but I don't remember it if I did, and I apologize. Your Honor, Bruce Blackwell of the law firm of King, Blackwell, Zender, and Wormuth. I am here today on a brief issue, and that involves the now noticed, which was done yesterday, deposition of Benjamin Crump. I am been retained to represent Parks and Crump, the law firm, as well as Mr. Crump individually. And if I may, just a brief bit of history to explain to the court why I'm here. As the court will remember, and I think the court remembers this case very well, in October there was a hearing. And this is the October 19th hearing. That hearing went on for about an hour and a half. Beginning at about 1.04 to 1.06 of that transcript, Mr. Crump, who is in the courtroom today, was in the courtroom. There was a question regarding Witness 8 and the recording of Witness 8. You called Mr. Crump beyond the bar. You asked him questions. He responded to those questions about people who were in the room or that could have been in the room, and you indicated at the time that he would be deposed. The rule that does that is 90.615. In Florida, that's a very unique circumstance because at that point the court makes this person a witness. Mr. Crump and his firm are counsel for the family and for the victim's family. He was retained shortly after the death of Trayvon Martin, and he has a number of potential claims available to the family that exist as of today. When he located Witness 8, and it was he who located Witness 8 with the help of Mr. Martin's father, they were able to ultimately get in touch with her. I think at the time, in October, the court believed she was in the room with them, because I've read the transcript, and that's what appears that the court was thinking. So the court asked a few questions. There was an indication, the belief was at the time that a telephone was used. In fact, we know now that it was a recorder put up to a telephone, as you said, the way we used to do it in the old days, the way that I still do it. And as a consequence, there were some responses back and forth, but what Mr. Crump intended to tell the court is that while the family clearly would cooperate in every way, he is a lawyer with pending claims. And so when we get to December, and you're hearing in December, essentially the issue that was before you was largely, if not completely, resolved, and that is they knew at that point that it was a recorder. They knew at that point the names of the persons who were in the room that the defense could put on their witness list. You'll remember that as of October the 19th, the state, under Rule of Criminal Procedure 3.220, had not listed Ben Crump or anybody in his law firm as a Category A, a Category B, or a Category C witness. And Mr. West, to his great credit, during that October hearing, said, but he's not even on a witness list. Your Honor, the concern that I have as an officer of this court, a fairly senior member of the bar, is that I'm concerned that we may be going fairly far afield to allow the deposition.
Can I interrupt you for
Yes,
a moment? It was for a very limited purpose, so let me suggest this. If the defense will propose what questions they want to ask.
May I stop you right there,
Yes.
Your Honor? With the greatest of respect.
Sure.
I have filed this morning and given to Mr. West, and I will acknowledge that they did not get it before this morning, because as of 9:55 last night, it was being finally typed. I have filed in open court a 15-page affidavit of Ben Crump. What I believe the court was looking at is the how, when, and where of this recording.
Yes.
This affidavit goes into great detail about the recorder, what the recorder does, what the recorder doesn't do, what he did, where it went, and an absolute, complete, full, and thorough chain of custody all the way into having watched the FBI office through a glass enclosure. I would ask the court that before we allow his deposition to go forward, that first of all, the court look at this affidavit. He is an officer of the court, but the subpoena we got was that they wanted to depose him for all purposes related to trial. And that was what was that was discussed in the December hearing as well. We want to do it not only for this recording, but his substantive knowledge about this case. I got a lot of cases, you don't make me do it now, it's obvious, but I got a lot of cases that say it is very unusual and almost never happens that you allow a lawyer. And in this case, he's essentially the private attorney general. At the time that he found this witness, the Sanford Police Department had not arrested Mr. Zimmerman and had essentially closed their investigation without finding out about Witness 8. So he was essentially acting in the role of the state, and the law is very clear with regard to prosecutors that you cannot take their deposition. Thank you, Your Honor.
Thank you very much. And I will read this and encourage counsel to read it, but this court's intention was only in regards to that actual taped interview.
Thank you, Your Honor.
Not to anything else having to do with the case. So
we do not have to appear for a deposition this afternoon.
Your Honor, we haven't even had a hearing yet. This was laid on my desk literally this morning, 3 minutes before the hearing started. I barely finished reading it, and the court is announcing a ruling already without even having read the...
on anything. I have not ruled on anything. The request just came, as you stood up, to not have to have the deposition today. So I have not ruled on anything. I had said that I will read this affidavit, encouraged counsel from both sides to read it. I had no knowledge a deposition is set. But if Mr. Blackwell is requesting that I enter an order,
No, I'm asking if you just postpone any taking of this
I was going
deposition
to
set for
say,
today.
postponing the deposition. What is your response to that?
I'm sorry, I don't understand. the
He's,
issue.
he's making an Ori Tennis motion to postpone the deposition pending the reading and possible ruling on this sufficiency of the affidavit.
Sorry, I thought the court was going to take a recess, read the affidavit, and then reconvene so we could address the issue.
No, I did not.
We have been working diligently to try to schedule this deposition. It's been going on for weeks. We coordinated with Mr. Crump and with the state attorney's office, who scheduled it with everyone's knowledge and consent for today. And Mr. Crump is here. This was all pre-arranged. I don't know when Mr. Blackwell entered the case, but this has been an ongoing discussion for weeks and weeks. We had been told by Mr. Crump by email some weeks ago that he was considering filing a motion. Certainly, Mr. Crump is aware of this court's order, as I assume Mr. Blackwell is. You should file a motion 48 hours at least in advance of the hearing if you want something heard. I'm just asking the court to read the affidavit, and then we'll discuss the legal issues involved before the court enters an order postponing or in any way limiting the deposition that we have scheduled for today.
Well, my recollection of my prior rulings, and I don't know if my statement reflects correctly what my intention was, but my intention was only regarding that one recording, not for anything having to do with the case. Now, I have not seen a notice of taking the deposition. I am not inclined, in this case or any other case, to be handed something that's 15 pages, go back, read it without doing any research on it, and coming right back and ruling of something of this importance. So I am going to postpone the deposition, not ordering that it cannot be taken. I will read, give it to the clerk to file it first, and I will read it. And if you need hearing time on that, you could call my judicial assistant, and I will make hearing time.
Thank you, Your Honor.
Okay, thank you all.
Your Honor,
Yes, sir.
Just, is the court being asked to rule on first whether the deposition can take place? And
No, the
second,
request
what
was-
the scope of it would be?
The initial request that I'm hearing right now is to postpone it so the parties can review and research the matters contained in this filing. If this suffices, there may not be any need to take the deposition. I'm not making a ruling on that right now.
By suffice, meaning that the affidavit would be submitted in lieu of deposition testimony?
Your Honor, if I could just be heard briefly. I talked with Mr. O'Meara. He and I have had cases together on the civil side over time, I think Friday before last. And I said, we think that we don't believe you should move forward with this deposition. He is counsel for the family. He has his own obligations as a lawyer, which the court recognizes from the Hickman v. Taylor case back in 1947 regarding work product. I said, but we are thinking about trying to put together a substantial affidavit, which I will tell you will include great numbers of things, to avoid us being put in a position of being asked things that could violate either the attorney-client or the work product privilege. And while they may have been discussing this, I have been telling, and my office told Mr. O'Meara's office on Friday, because I was in Tallahassee from Wednesday through Friday, that we were not conceding that a deposition would go forward. And now we did get the notice yesterday, and it's the normal, it's what I would anticipate I would get in a deposition, that is as broad as it can possibly be. And that's the concern I have as a senior officer of this court and on behalf of my client.
Well, and instead of the parties going through a deposition where the witness is not going to answer and may be just a waste of time, let's review what's in this affidavit, and we may not need to go further with it.
And I wish I could have gotten it done sooner, Your Honor, but Mr. Crump lives in Tallahassee. And he and I were not able to get together until yesterday afternoon.
Okay.
Thank you,
Yes.
Your Honor.
We're going to have some questions that are perhaps touched upon on certain matters that are addressed in the affidavit. I know that from having looked at it. There are also other matters where we believe Mr. Crump has relevant information that would subject him to a deposition under Rule 3.220H1, where
You have to put that forward in a motion because Mr. Crump was not listed as a Category A witness, and the court made Mr. Crump its own witness for this sole purpose. I will go back and read the transcripts of that, but I have made my ruling.
May I direct the court's attention to the specific provision of Rule 3.220 of which I'm speaking.
Yes, you may.
It's Rule 3.220 sub H A that says the defendant may, without leave of court, take the deposition of any witness listed by the prosecutor as Category A. We know that. It also says that after receipt by the defendant of the discovery exhibit, which we have already received, the defendant may, without leave of court, take the deposition of any unlisted witness who may have information relevant to the offense charged.
Okay, well, we haven't read this affidavit yet. I have not read the affidavit.
Mr. Crump has information beyond just the four corners of that affidavit.
I don't know that because for the third time I'm telling you I have not read it. I will go back and read it. I will again reiterate the deposition is postponed. If this affidavit is not sufficient for your purposes, then if you need a hearing about it, I will have set aside hearing time other than what has previously been announced to address this issue. Okay. Anything further that we need to hear, that the court needs to rule on?
Not for me, Your Honor, thank you.
Just
Spence?
one moment, if I might, just to
Yes.
make sure that all the orders have been entered. And
So I can pull it up? Okay. We'll set that for March 5th. Did you get everything you needed?
I did, thank you.
Okay, thank you. Anything further from the state?
No, Your Honor.
We'll set the docket sounding until March 5th. Thank you. Court is in recess.